Hello everyone, I hope you are having a lovely day. Today I'm revisiting one of the topics that I already dealt with. They are concerning the customary marriage. Um, it's very interesting. I have two cases that I came across. The other one is that of Mgenge versus Mukwena, and another, which the judgment was granted on the 14th of March 2023. It was because in this matter, it's because it dealt with the recognition of the customary marriage. And there was a marriage certificate that the applicant, not the applicant, the respondent, being the wife to the deceased. That is why I've been saying to people, please, please, please make sure that within 3 months after you have celebrated your customary union, after umembe, so they are different because we from different cultures. Within 3 months after the negotiations and the celebrations, you have to get your customary marriage registered within 3 months. That is what the court has said, that within 3 months your customary marriage has to be registered, and even the act actually says so, that you have to register within 3 months. And any of the parties to this customary marriage can register. It's not, it doesn't have to be both of you at the same time. No, any of the parties can arrange that the marriage is registered. And for those that have been married customarily years back, before even this act was promulgated, you can still register. In this case, it's because the one of Genge versus Mukwena, it's because the mother-in-law was now challenging the validity of the marriage certificate, stating that the customary union did not, the one that was entered between her son and the respondent, was not a valid customary union, because of there was still some other things that needed to be done, like handing over and paying the outstanding amount, because in our culture, people come and pay a certain amount, and thereafter they have to come and pay the rest of lobola. So the mother of the deceased, being her son, said because of that was not done, so she does not recognize the marriage being valid. However, this is what the court said: whether you've paid the full amount of lobola, whatever that was asked for you to pay, or you've paid part of it. Firstly, that the people that are getting married customarily were above 18. Secondly, that both parties have agreed to be married customarily. Thirdly, that there has been a celebration. That is a conclusion of customary marriage, which it is valid. And in this case, the application of the mother-in-law, the mother to the son, who is now deceased, her application was dismissed because all the requirements for the customary marriage to be recognized were met. So, and people need to know at the same time, it doesn't mean when you don't have a marriage certificate, the customary union is not valid. It is valid. So, however, it is advisable that you register. In that way, when you've got the certificate, it is proof. Anyone that has to dispute that marriage, they will have to come and address the court and state why they think that is not a customary marriage. Now, let's come to the second case. This one we know that as long you meet the requirements that are stated in the Act, which is the Recognition of Customary Marriage Act 120 of 1998. The second case that I have is that of Khashane versus Minister of Home Affairs and others. This one, it was delivered in 2024 January the 12th. This one is very important because of seriously we've been having issues with home affairs, whereby when people want to register their customary union, the officials will actually send them back and say, approach the courts. That is very wrong because there are requirements that the court officials need to follow in order to register the customary marriage. In this case, again, the husband of Khashane had passed on. And when she went to the master's office to get a letter of authority, she was sent back because they said she doesn't qualify to apply. So then she approached the High Court. Then she went to the Home Affairs. The Home Affairs officials informed her, no, we are not going to register your customary marriage. So what she did was to approach the High Court to get relief, in a sense that the Home Affairs need to be ordered to register the customary union, and at the same time to furnish the applicant with a marriage certificate. So in this case, when she approached the High Court actually, in this case, they actually dealt again with that case of, what is it? They dealt with the case of, what's the name? Sambo, where Judge Mokhwatleng actually said the Act doesn't say if there is no handing over of the bride, then the marriage is invalid. The Act says, one, the person has to be above 18. Well, we know if you marry, you are under 18, then you need to get permission and consent from your parents or your legal guardian. So in this case, the Act says the people need to be 18, above 18. Secondly, that there has to be negotiations, and at the same time, the parties need to agree to marry to marry customarily. So if those requirements are met, then it means it is a customary union. So, and the judge was not happy with the Home Affairs Court officials. And I've had a situation where I had a client, she needed to register her customary union. And the officials, they actually refused. I even spoke to the officials, saying to them, but ma'am, all the requirements have been met. Why now do you say you cannot register? While the Act says immediately after the celebration, you can register your customary union marriage. And this woman told me, because I'm now speaking from experience, from the court, what you call the Home Affairs official, who said, no, my client should approach the High Court. And this case of Khashane is the case, I would say, for those that will have a problem, similar problem, where the officials are refusing to register your customary union. I would advise that you get the case and show it to the official that the court actually said, the officials, if the party have met the requirements, which I've already stated, then they need to register. There's no need to send them to court, which is the High Court, where it's going to be expensive to actually for the person to pay the costs. Officials are problematic sometimes, and I feel like especially where a person is stranded, a person needs to make sure that they actually follow cases that already have been decided before they send people away. So in this case, the court found that the Home Affairs were at fault, the Home Affairs officials, because all the requirements were met. And on top of that, they actually said, if the issue is because there was no handing over, that is not, it's actually unconstitutional. And the Act did not say that should be part, and really it's not there. On the Act, you'll not find that. So the application was based on Section 4(7), where the person said once they want the court to order Home Affairs to make her customary union valid, which the court granted. On top of that, they were ordered that they should register the marriage and give the applicant the marriage certificate. So this is just to make you aware that even though you don't have, your marriage is not registered, it's still valid. So please, I hope this information will assist you. Have a lovely day. Thank you. Mwah.